all attorneys have had the chance to look at it already. Ms. Moss is looking at it now. And it'll be included in the record as court's exhibit number 1. I'll be bringing that juror in just to explain that he will be continuing to serve on this panel. But it might help ease his concerns if we can give him an estimate of how long it is that we expect that the case might take. Do we have any reasonable estimate that both sides can agree on?
Your Honor, I would think that we would finish this week, certainly, and because of the issue that I spoke about earlier with the transport of the witness from Portland, certainly the state's case would go into Monday.
Okay.
Of course, I can't anticipate what the defendant intends to do, which may change this, but I would think certainly we would be done by the end of next week. That's an absolute.
Okay. Does that seem like a fair estimate I can share with him, Ms. Moss?
Yes, sir.
Okay. Would you please bring in juror number 99 for me? Good morning, sir. How are you today?
Good morning.
I got your note from yesterday. I've had the chance to look at it. Both sides have had the chance to review it as well. I did want to let you know, sir, that of course jury duty imposes certain responsibilities on everyone that's a citizen of our community. Those demands, of course, sometimes require people to step away from what they would otherwise normally be doing with their lives, and you have been selected to serve in this case, so you will continue to serve as one of the jurors impaneled in this case. But to ease your mind to the extent that it might be helpful in any way, both sides seem to agree that we'll conclude this trial sometime next week. So not the 3 to 4 weeks you might have imagined, but we'll probably be done sometime next week. Thank you very much, sir. You can go back with your fellow jurors.
All right,
All right, and now with the juror out of the courtroom, is the state ready to proceed?
State's ready, Your Honor.
Is the defense ready?
Defense ready.
Please bring our jury.
Your Honor, my understanding is I think you have to click something in order to make that screen black for the initial proceedings, I think.
I hope I'll be able to undo that if I do that.
Fix it when we get there, Judge, if that's a problem.
Okay, you want me to power it off?
Mr. Swilling may be able to fix it.
Okay.
If you would let him approach me.
Sure.
If he knows what to do. Because I'm not going to pretend I do. Thank you.
Yes, sir. You can be seated. Thank you very much. Good morning, ladies and gentlemen. Welcome back. It's good to see all of you. Before we can proceed any further, I have one additional oath to administer to you. If you'd each raise your right hands for me. You shall well and truly try the issue formed upon this bill of indictment between the state of Georgia and Tiffany Nicole Moss, who is charged in count 1 with murder, counts 2 and 3 felony murder, counts 4 and 5 cruelty to children in the first degree, and in count 6 concealing the death of another, and a true verdict give according to the evidence. And if you will, say I will. Thank you. Ladies and gentlemen, you can put your hands down. Ladies and gentlemen, you have been sworn and impaneled, and you are about to try a criminal case entitled The State of Georgia versus Tiffany Nicole Moss. The defendant, Tiffany Nicole Moss, has been indicted by the grand jury of Gwinnett County in an indictment composed of the following counts that I will read to you at this time. Count 1. The grand jurors aforesaid, in the name and behalf of the citizens of Georgia, charge and accuse Tiffany Nicole Moss with the offense of murder. For the said accused in the county and state aforesaid between the 24th day of October 2013 and the 2nd day of November 2013, the exact date of the offense being unknown to the grand jury, did then and there unlawfully and with malice aforethought cause the death of Emani Moss, a human being, by withholding sustenance necessary to sustain human life, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 2. The grand jurors aforesaid, in the name and behalf of the citizens of Georgia, charge and accuse Tiffany Nicole Moss with the offense of felony murder. For the said accused in the county and state aforesaid, between the 24th day of October 2013 and the 2nd day of November 2013, the exact date of the offense being unknown to the grand jury, did then and there unlawfully, while in the commission of a felony, to wit, cruelty to children first degree, caused the death of Emani Moss, a human being, as alleged in count 4 of this indictment, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 3. The grand jurors aforesaid, in the name and behalf of the citizens of Georgia, charge and accuse Tiffany Nicole Moss with the offense of felony murder. For the said accused in the county and state aforesaid between the 24th day of October 2013 and the 2nd day of November 2013, the exact date of the offense being unknown to the grand jury, did then and there unlawfully, while in the commission of a felony, to wit, cruelty to children first degree, caused the death of Emani Moss, a human being, as alleged in count 5 of this indictment, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 4. The grand jurors aforesaid, in the name and behalf of the citizens of Georgia, charge and accuse Tiffany Nicole Moss with the offense of cruelty to children first degree. For the said accused in the county and state aforesaid between the 24th day of October 2013 and the 2nd day of November 2013, the exact date of the offense being unknown to the grand jury, did then and there unlawfully and maliciously cause Emani Moss, a child under the age of 18 years, cruel and excessive physical and mental pain by withholding necessary sustenance to sustain human life, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 5. The grand jurors aforesaid, in the name and behalf of the citizens of Georgia, charge and accuse Tiffany Nicole Moss with the offense of cruelty to children first degree. For the said accused in the county and state aforesaid between the 24th day of October 2013 and the 2nd day of November 2013, the exact date of the offense being unknown to the grand jury, did then and there unlawfully, being a parent of Emani Moss, a child under the age of 18 years, willfully deprive said child of necessary sustenance, to wit, food and water necessary to sustain human life, to the extent that the child's well-being was jeopardized, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 6. The grand jurors aforesaid, in the name and behalf of the citizens of Georgia, charge and accuse Tiffany Nicole Moss with the offense of concealing the death of another. For the said accused in the county and state aforesaid between the 24th day of October 2013 and the 2nd day of November 2013, the exact date of the offense being unknown to the grand jury, did conceal the death of another, to wit, Emani Moss, and did thereby hinder the discovery of whether such person was lawfully killed, contrary to the laws of said state, the good order, peace, and dignity thereof. To this indictment that I have just read to you, the defendant has pled not guilty and denies each and every allegation therein. This is what forms the issue that you have been selected, sworn, and impaneled to try. Before we begin the trial, I'm going to give you some preliminary instructions on fundamental principles of criminal law. I will also instruct you on the role of the judge, the jury, and the lawyers, and give you an overview of the trial procedure. Many of you may have never served on a jury before. It is therefore necessary that these instructions be given so that you have a general understanding of procedure in a criminal trial, what will be expected of you, and how you are to conduct yourself during the trial. Under the procedures followed in Georgia, certain criminal trials are conducted in 2 stages. In the first stage, the jury determines the guilt or innocence of the accused. If the jury determines that the accused is guilty, then the state and the accused both have a right to submit additional evidence in aggravation or in extenuation and in mitigation of the punishment to be imposed. After hearing any such evidence and argument, if any, the jury then retires to again consider the sentence and determine the punishment to be imposed. The penalty set must, of course, be within the limits set by law, and those instructions I will give you at an appropriate time. The defendant is charged in the indictment with crimes that are violations of certain laws of the state of Georgia. I want to emphasize to you that the indictment, including all the counts therein, and the plea of not guilty are the legal procedures by which these criminal charges are brought against the defendant. The charges and plea of not guilty are not evidence of guilt, and you should not consider them as evidence or implication of guilt of any crime whatsoever. This defendant is presumed to be innocent until she is proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in her favor, and this presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the crime or crimes charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. It is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence or a lack of evidence, a conflict in the evidence, or any combination of these. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to prove her innocence. If after giving consideration to all the facts and circumstances of this case, your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law and you should acquit the defendant. But if no doubt exists in your minds about the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. Under our system, it is my duty as the trial judge to determine the law that applies to this case and to instruct you, the jury, on the specific rules of law that you must apply to the facts in arriving at a verdict. I'm giving you some of those instructions now. I will give you more detailed instructions after the evidence has been presented and the parties have made their closing arguments. During the trial, I may be called upon to rule on motions or objections to evidence. Nothing I say in making these rulings or at any time during the trial is evidence and should not be considered as an indication that I have any leaning in this case whatsoever. My only interest in this case is to see that it is fairly tried according to the laws and the Constitution of the state of Georgia and the Constitution of the United States. The parties are bound to follow applicable laws, trial procedures, and rules of evidence during the trial. If at any time they believe that any law, procedure, or rule of evidence is being violated, they may make motions regarding the conduct of the trial or objections to the admission of evidence. In making these motions or objections, the participants are simply seeking to fulfill their duties to their side and to the court. Sometimes these motions or objections may require the court to consider outside of your presence the questions raised, and you will be excused to the jury room. We will try to minimize the number and length of these interruptions and ask for your patience in this regard. Ladies and gentlemen, every citizen has the constitutional right to represent themselves should they choose to do so. In this case, the defendant has chosen to exercise that right and has chosen to represent herself. Nothing regarding the defendant's choice to exercise her constitutional right to represent herself shall be construed either for or against the defendant or for or against the state. Ladies and gentlemen, trial procedure in a criminal trial is generally as follows. First, both sides have the opportunity to make what is called an opening statement. This opening statement is not evidence. Remember that what is said in opening statements is not evidence, but is a preview or an outline of what they expect the evidence to be. Following the opening statements, the evidence will be presented. Evidence can be in the form of testimony given by witnesses or physical evidence that will be labeled with exhibit numbers for identification. After the presentation of all the evidence, the participants have the opportunity to make what is called a closing argument or summation. At this time, the participants may suggest which laws are applicable and how they should be considered in light of the evidence and point out to you certain parts of the evidence that they think are favorable to their position. The goal of a closing argument is to persuade you to decide the case in their favor. Following the closing arguments, I will charge you more specifically on the law that applies to this case. I will then ask you to retire to the jury room to deliberate and reach your verdict. The jury has a very important role. It is your duty to determine the facts of the case and to apply the law to those facts. I will instruct you on the laws that apply to this case, but you must determine the facts from the evidence. Evidence, by definition, is the means by which any fact in issue is established or disproved. Evidence consists of two things: testimony and exhibits. Testimony is the testimony that you will hear under oath from those who take the witness stand. Exhibits are those documents, photographs, or other physical evidence that are admitted into evidence. Ladies and gentlemen, the object of this trial is to discover the truth. During the trial, the admission of evidence will be governed by certain rules of evidence. Those rules were drafted with one prominent purpose in mind, and that purpose is the discovery of truth. Consequently, the rules of evidence seek to assure that only the best and highest evidence is admitted for your consideration. During the trial, the participants have a right to object to the admission of evidence if they believe its admission would violate a rule of evidence. I will admit or exclude the evidence according to those rules. If I overrule an objection, this means that you are allowed to consider the evidence being offered. On the other hand, if I sustain an objection, this means that you may not consider the evidence being offered. You should consider only that testimony and only those exhibits that are admitted, and you should draw no inferences and make no assumptions about the evidence objected to if the objection was sustained. In the event that you hear or see any inadmissible evidence before an objection can be made and ruled upon, if the objection is sustained, I will instruct you to disregard it, and you should disregard that evidence entirely in your deliberations and in arriving at your verdict. You, the jury, must determine the credibility and believability of the witnesses. It is for you to determine which witness or witnesses you will believe and which witness or witnesses you will not believe if there are some whom you do not believe. In determining the credibility or believability of witnesses, you may consider all the facts and circumstances of the case, the manner in which the witnesses testify, their interest or lack of interest in the case, their means and opportunity for knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, and the occurrences about which they testify. You may also consider their personal credibility insofar as it may appear to you from the trial of the case. As the fact finder, it is your duty to believe the witnesses whom you think are most believable. It is for you alone to determine what testimony you will believe and what testimony you will not believe. Ladies and gentlemen, it is important that you pay close attention to the evidence as it is presented during the trial. If at any time you are unable to hear or see any evidence being presented, or if you are suffering from any discomfort that diverts your attention, please feel free to inform me, and I'll do whatever is necessary to assure that you are able to hear and see the evidence being presented and give it your undivided attention. It is important that you view this evidence with an open mind at all times and reach no final conclusions until the trial is over. Do not jump to conclusions before all the evidence is presented. Also, remember that during the course of the trial, it would be improper for you to discuss this case with anyone or to allow anyone to discuss the case with you or in your presence or hearing. This applies even to discussions amongst yourselves in the jury room or elsewhere before actual deliberations begin. In a moment, I'll ask the bailiff to provide you with pens and notepads for your use during the trial. You may take notes, but you are not required to do so. If you decide to take notes, please remember that note-taking should not divert you from paying full attention to the evidence and evaluating witness credibility. Your observations of the witnesses during their testimony can be vital to your determination of the believability of their testimony. The notes that you take are for your use only and are not to be shared with anyone until you begin deliberation with your fellow jurors. Notes are not evidence, only memory aids, and should not take precedence over your recollection. It is the duty of each juror to recall the evidence, and while you may consider another juror's notes to refresh your memory, you should rely on your own recollection of the proceedings. Do not be influenced by the notes of other jurors unless their notes help you in determining your own independent recollection. Notes are not entitled to any greater weight than the recollection or impression of each juror as to what the evidence may have been. After the trial is over, the notes will be collected and destroyed. I instruct you, ladies and gentlemen, that you must decide this case for yourself solely on the testimony you hear from the witness stand and the exhibits admitted into evidence. You may not visit any scenes depicted by the evidence. You may not utilize any books or documents not in evidence during your deliberations. You may not read or listen to any accounts of the trial that might appear in the news media. You may not discuss this case with anyone other than your fellow jurors during deliberations. To preserve the integrity of the jury system, you as finders of fact must decide this case solely upon the evidence presented in this courtroom. This means that during the trial, you must not conduct any independent research about this case, the matters in the case, or the individuals involved in the case. In other words, you should not consult dictionaries or reference materials, search the internet, websites, or blogs, or use any other electronic tools to obtain information about the case or to help you decide the case. Please do not try to find out information from any source outside the confines of this courtroom, to include media of any sort or online legal research. I know that many of you use cell phones, Blackberries, the internet, and other tools of technology. You also must not talk to anyone about this case or use these tools to communicate electronically with anyone about this case. This includes your family and friends. Communicate with anyone about the case on your cell phone, through email, Blackberry, iPhone, text messaging, or on Twitter, through any blog or website, through any internet chat room, or by way of any other social networking websites, including Facebook, MySpace, LinkedIn, and YouTube. Ladies and gentlemen, you also might have noticed that there's cameras in the courtroom. To the extent that you might be concerned about that in any way, those photographers and those camera people have been instructed that they shall not and may not photograph you as jurors in this case. Mr. Hagee, would you please hand out the notepads for me, please?